Hello, everybody. I'm just going to wait another minute or so before I introduce today's speakers to allow people to log on. All right. Well, good morning, good afternoon, and good evening to you all, and welcome back to the Administrative Law and Governance Colloquium. This year's topic is Frontline Administration, and I'm very happy to be joined today by Margaret Doyle and Nick O'Brien, who are going to be discussing their wonderful book, Reimagining Administrative Justice. I'll briefly introduce Margaret and Nick, and then Margaret and Nick are going to have a discussion touching on the major themes of the book. And then after that, as usual, we'll have time for questions and answers. Margaret Doyle is a visiting research fellow at the University of Essex School of Law in the United Kingdom. Her research interests include administrative justice, dispute resolution, in particular mediation, special educational needs, and equalities and discrimination. She is also an independent mediator and has specialized in disputes involving equalities and disabilities for 20 years. Margaret's educational background includes graduating from Barnard College, Columbia University, with a bachelor's degree and a master's degree in research in law and socio-legal studies with distinction from Birkbeck University of London. Margaret was a member of the team that set up the UK Administrative Justice Institute, a UK-wide network for administrative justice research based at the University of Essex School of Law. She is a member of the academic panel of the Administrative Justice Council of the UK. She has conducted research on mediation and judicial review with the Public Law Project, on court-based mediation for the Ministry of Justice, and on mediation and ombuds for the Equalities and Human Rights Commission. Her most recent research is a knowledge exchange project exploring young people's involvement in challenges against statutory local authority decisions on assessment of and support for their educational needs and their participation in mediation as one of the key mechanisms by which such challenges can be made. And I'll put a link to that project in the chat in a moment. Nick O'Brien, Dr. O'Brien is an honorary research fellow at the University of Liverpool, again in the United Kingdom, and a part-time tribunal judge at Her Majesty's Courts and Tribunal Service. His research interests include mental health, special educational needs and disability, and administrative justice. Dr. O'Brien's educational background includes graduating from Hertford College, Oxford, with a BA and MA in Classics and a PhD in Philosophy from the Keele University School of Law. Dr. O'Brien has been a senior official at the Legal Services Ombudsman for England and Wales, a director of legal services and operations of the Disability Rights Commission, an advisor to the UK Parliamentary and Health Service Ombudsman, and specialist advisor to the House of Commons Public Administration Select Committee for its report, Time for a People's Ombudsman Service. And Dr. O'Brien was also awarded the Bernard Crick Prize for the Best Piece in Political Quarterly of 2018. And most importantly of all, Nick and Margaret have written a wonderful book entitled Reimagining Administrative Justice, which takes a frontline perspective on the administrative state, and which is a challenging and provocative read for those of us involved in administrative law. I greatly enjoyed reading the book, and I'm very much looking forward to our discussion today. So I'm going to hand it over to the two of you. I'm going to disappear, and I'll reappear at the end when your discussion is winding to an end and it's time to involve the audience. Thank you again, Margaret and Nick, for being with me today.
Thank you, Paul. Thank you very much. Thank you for inviting us. We're really thrilled to be part of what's been a wonderful series. Yeah, so Nick and I are just going to have a conversation between us really for about 40 minutes, I think, and then there should be plenty of time for discussion after that, and we'll just touch on some of the where the book came from, really, and some of the key themes in it. So, Nick, you and I have been working in and writing about administrative justice for some time, about mediation and human rights and the Ombudsman institution. We've gone to many events on administrative justice together over the years and had conversations about it. And I think really the book comes out of a shared sense of disappointment, I guess, disappointment with the status quo, and a shared desire to shake things up. Do you agree with that?
Yeah, well, I think that's right, Margaret. I mean, I think the first thing to say is that we don't really see ourselves as primarily academic commentators, although we've certainly both drawn on our practical experience of administrative justice to reflect and comment. But I think it's fair to say we're practitioners first and commentators second. But as you say, between us, we've got decades of experience, probably too many decades, if truth be told. And we've got a mixed bag of tribunal work, mediation, disability rights and equality commission experience, and in particular various roles with various ombudsman schemes, various ombud schemes. And although there's been a lot that's been really good about that, I think we both had an abiding sense of frustration and of missed connection and of missed opportunity in a sense. And it's that frustration really that fueled the writing of the book. And I think gradually over time, we came to think that this sense of loss came from witnessing two ships crossing in the night, if you like, always just missing each other and somehow sailing off into the dark. And those two ships were administrative justice on the one hand and human rights on the other. And somehow those two things, administrative justice and human rights, somehow seem to dance around each other in common law jurisdictions without ever quite getting it together. And so I think we wanted to explore that misalliance and do a bit of matchmaking, perhaps slightly mischievous matchmaking, it could be said. And so the book was really, to that extent, something of an essay in the literal sense of that word, a venture out into the unknown, certainly not a perfectly formed and finished thing. And so it was an opening gambit in the conversation, really. And I think it became clear that in the end, that conversation was one about democracy and the achievement of a form of administrative justice that through its alliance with social rights rather than civil rights could be more recognizably democratic. And I think that's how we came to see it. I'd like to think we had a very clear shared vision about that. But correct me if I'm wrong, by all means.
No, definitely. Well, definitely that intention for it to be an opening gambit, to be what we call a bit of a modest manifesto for change. I think we've seen too many calls for really unambitious reforms in this area and too few creative attempts to reimagine it. Sometimes I feel about the state of administrative justice, it's like the popular theme of most country music, you know, I love you, but you disappoint me, and I think it can be better. And that concept of administrative justice and human rights sort of dancing around each other and being out of sync, and in some ways perfect dancing partners, but not quite getting it right, is such a vivid and apt image. I'm just going to do screen share and, oh, sorry. Paul, it seems to have disabled screen share for me.
You should be able to share it now.
Yeah. Ah, thank you. Lovely. Right. Thank you, Paul. Yeah, on just on the topic of images, I wonder, Nick, if you want to say a little bit about the really striking image up on the screen here.
Yeah, well, this is a sculpture that in the long lost pre-COVID days I used to pass quite regularly when I was a visitor to the Royal Courts of Justice on the Strand in London, where I was sitting on the Special Educational Needs Tribunal, which is the tribunal in the UK, or in England, Wales anyway, for hearing appeals against local authority decisions on educational provision for disabled children and young people. And it always struck me as a daunting image. I mean, in some ways quite terrifying, really, and entirely inappropriate for a tribunal, let alone one dealing with special educational needs and children. And more than that, it seems to conjure up a particular image of the law, something very steely and muscular, very masculine and aggressive, in fact. And it's all about adjudication and enforcement. Whereas administrative justice, I think we came to feel, is surely much more about relationships between citizens and street level bureaucrats, frontline workers, if you like, ordinary folk and public authorities. And so we wanted the book to capture something of the misalliance between this rather macho image of the law on the one hand and its realities in the small places of ordinary life. And this was actually a sculpture that was created by a Viennese sculptor called Siegfried Charoux, who sought refuge in the UK from Austria in 1935. And then both before and after the Second World War became quite prominent in public sculpture and public art. And he made a very pleasant comment, I think, about this statue in particular, which was part of a series that he did. And he said that the judge, this statue, the judge represents justice with a capital J, in the sense, as he puts it, of jurisprudence and jurisdiction. And it represents justice in that inhuman form, which humankind all over the world now tolerates, drapery and an obsession for punishment, which I think is a great expression, and it's such a striking image. And curiously, it was actually commissioned by Gerald Gardner, who became the Lord Chancellor in the Harold Wilson Labour government in the UK in 1964, who interestingly, a couple of years later, introduced the second reading of the bill creating the Parliamentary Commissioner for Administration, which is the ombud institution in the UK. He introduced that in the House of Lords. So there's some quite pertinent connections, and this statue now sits in the Queen's Building on the Strand as part of the Royal Courts of Justice. So it struck us, I think, as a very strong image in a sense of what we wanted to challenge and work around.
Mm. Yeah, really interesting connections there, and a great visual of what we were up against, as you say. I think for me too, administrative justice here in the UK has become a sort of vast assembly line of complaints and appeals and disputes, and with ever more resources being needed to be poured into its operation, but with no real evidence that it improves that fundamental relationship that's at the core of administrative justice, that relationship between citizens, non-citizens, between people and the state. And that's shaped by initial decision-making that's really decision-making at the front line on issues that affect everyday lives. So the areas we're talking about very much are decision-making on education, on housing, on health and social care, on social security, on immigration, about human rights in the small places that Eleanor Roosevelt spoke of in her speech to the UN in 1958. And of course, we're not talking always literally small places, but small places in the sense of everyday, ordinary, close to home, unseen on maps of the world, as she said. And they're such crucial and human issues, but it all feels very transactional and unsustainable. So I think we want to talk a bit about how we got to where we are, but also kind of what the remedy is. And I think for us, the remedy lies in reframing how we think about the role of the state and about good administration as a positive force in a healthy democracy, and also about a focus on social rights as the sort of the means to gain traction for change and bring more relevance to the institutions within administrative justice. Do you want to say a little bit more, Nick, about those sort of main argument in the book?
Yeah, so we wanted to show really how and why administrative justice and human rights had drifted apart in the way that we mentioned before, how that misalliance had come about, and particularly given that they had what we saw as being common origins in the post-war social democratic moment. And of course, that expression social democratic moment is is not literally a moment, but it's more an entire sweep of mid-20th century history from roughly, I suppose, 1945 until the mid-70s, when things began to take a very different turn, a turn that political economists would probably describe as neoliberal, lawyers perhaps as a turn towards a form of constitutionalism. So we detected a common path for administrative justice and human rights, a common path towards an emphasis on the codification of individual rights and regulation of the administrative state by individual enforcement. But that was a common path that ironically, and perhaps in some ways even paradoxically, led to separation rather than connection ultimately. And so our primary resources for trying to make a reconnection in the book are for the most part, on the one hand, historical and on the other, cultural. So historical in the sense of being rooted in that post-war social democratic moment for a different vision from that which prevails now. And cultural in the sense of being rooted in patterns of thinking about design in all sorts of different corners of social life. So in the book, we identify a cluster of linked pathologies, as we put it, that are rooted in different forms of individualism, libertarianism, and legalism. And that triad, if you like, are opposed to values that are much more communitarian, egalitarian, and democratic. And so we find in that post-war historical context, which of course was not without its own limitations and pathologies in its own right, but we find there nevertheless a vision of both administrative justice and human rights that has a very different feel from that prevailing today. And so we try to show, really, to put it crudely, that both administrative justice and human rights have been hijacked along the way by forces associated with neoliberalism, and in the context of public administration in particular, with the new public management. So to get a handle on those forces in a more concrete way that works for both administrative justice and human rights, we focus on two sets of concepts that are in tension with one another. So the currently dominant set we identify as first the individual user as a rights bearer. Secondly, a fairly mechanized system of administrative justice with closely policed internal boundaries. And thirdly, dispute resolution as a form of one-off closure. So that preoccupation with individual rights, individual enforcement, and the individual user experience, we argue, detracts from the bigger picture of the individual as rooted in civil society, as embedded in a social context, and also of public administration as a set of practices rather than just building blocks of a systemic silo. The concern with policing the boundaries of a mechanistic system of administrative justice, we say, creates a world in which judges know very little of ombuds, and ombuds have little to do with tribunals, and no one institution is in a position to share intelligence and take a common or strategic approach. And then thirdly, the pursuit of individual dispute resolution as the overarching aim seems to idealize closure in a way that increasingly seems to us unrealistic, and that's really in danger of downplaying the need for restorative outcomes and remedies that are more than just forms of individual redress. So against all that, we try to revitalize an alternative set of emphases. First of all, community as a way of resituating the individual in a social context where lots of people encounter the same problems and aspire to shared solutions. Secondly, network as a means of connecting administrative justice institutions so that there's a sort of administrative justice dividend, if you like, that derives from cooperation and coordination across institutional boundaries. And thirdly, openness in the sense of open-ended and deliberative, perhaps even iterative forms of decision-making that don't necessarily have the adversarial trial as their ideal template. So we designate these alternative conceptual sets respectively as jurisprudential and demosprudential to capture the competing priorities respectively of legalism and of democracy. And in short, we argue that if administrative justice and human rights ships are ever to meet in the night, then the demosprudential must take precedence over the jurisprudential.
I got a feeling that from some reactions to the book, Nick, that demos prudence is a bit of an unfamiliar mouthful to some people. But what it means in essence is an approach that aims to democratize the processes of responding to citizen and non-citizen grievance. One that uses techniques of civic participation, reciprocity, bridge building. And it offers a different way to inhabit this space where the law and state decision making touch people in their everyday lives. And it allows us to focus not so much on individual entitlement, which of course leaves individuals the lonely task of rights enforcement in what is essentially an adversarial battle of resources. But instead sees individual empowerment to exercise social rights as more of a collective endeavor. I'm just going to change my slide here. In design terms, it's a form of, I would say demos prudence is like a form of social innovation that's loosely designed to accommodate many voices, not just the loudest, and to embrace the public interest. In the book, we write a bit about administrative justice being more of a fabric than a system, with texture and nubs, not all seamless and smooth. And here's a picture of a weaving by Annie Albers, who was a member of the Bauhaus School. And this weaving dates from the late 1950s, about the same time as the Franks Committee here reported on its review of administrative tribunals. That review was one of the first attempts by the state to really design the administrative justice system and to establish design principles for it. And when we were working on the book, we went to a lot of exhibitions, art exhibitions, including one of Albers' work. And I think when we saw this and the other weavings on display, we were both struck by her emphasis, how her emphasis on touch and texture, on the haptic, and by how her designs reflect our sense of the richness really of an organic fabric over a more controlled system as a way to describe administrative justice, of what Albers herself referred to as interconnected threads that when connected form a flexible and cohesive whole. And I was really pleased when Bernardo Zacca mentioned in his presentation here in this series a couple of weeks ago, the designer Margaret Calvert. He was referring to her in relation to the UK government's online platform gov.uk, for which she was a consultant and designed the typeface. And he was talking about the way its priority of sort of rapid one-way information conveyancing is so much not what's needed in terms of exchanges between citizens and frontline bureaucrats. In our book, we mentioned Calvert in relation to her work on the UK road signage overhaul, which began with the first motorway being built, the Preston Bypass, in 1958, and was later rolled out to all roads across the country, and is still in use today. And this was a major exercise by government in system design. And it was happening at the same time as the Franks Committee design of administrative justice principles. And although they were both very different exercises, obviously, they both resulted in more consistency and more system. There's a sort of purity of modernist clean lines on the one hand, and increased judicialization and legalization on the other. And these are photographs from the Design Museum showing the sort of road signage system that was in place, that was a bit ad hoc and messy and not at all clean and modernist on the left. And then, of course, Calvert Engineers designs on the right. And these large-scale state-sponsored design initiatives were part of that social democratic moment that you described, Nick. And that was a period when design had a fiercely ethical dimension. So in looking at design culture and what it had to say about administrative justice, we looked at design sources and particularly the way design in the 20th century took a similar trajectory to that of administrative justice and human rights, from the emergence of all those ideas in that moment after World War II, and through to their capture by consumerism and neoliberalism and legalism toward the end of the 20th century and into the 21st. And we drew on a lot of sources in the design world, including the work of design thinker Ezio Manzini and his idea of design for social innovation, and sociologists, urban thinkers, Anna Minton and Richard Sennett, looking at the design of the public realm, and others, to consider this relationship between designers and users and the role of the state in design commissioning and the influence of design thinking as well. Here we have, just to say, also that direction of that trajectory in the in design is reflected in the sort of trajectory of the increased use of the sort of consumers' use of the term user in administrative justice, with terms like user perspective and user friendliness rolled out as the ambition, without any real interrogation of who the user is. This is something my colleague Joe Tomlinson has written quite a lot about as well over here. And here's another photo from the Design Museum. This is from their permanent exhibition on the history of design, which charts the relationship between designer, maker, and user. And in this image, you can see the sort of systematic triangular tessellation of those colored tiles in the sign as a sort of visual expression of that relationship. And of course, the dominance of the user is writ large here, literally, as it has been in concepts like citizen choice and the user as a consumer of justice. We've put up here a quote from the white paper in 2004 on transforming public services, and it's really quite interesting in that document the way the user perspective is the predominant sort of ambition, but it was very much about designing it as you would design a service, a cost-effective and efficient service for a user, for a customer. And I think generally in administrative justice, user-led design has been couched in the language of consumer journey and customer satisfaction. So that all sounds a little bit dire and maybe a little bit harsh, I don't know. But in fact, the book is a hopeful one, I like to think. And it's one that offers a sort of different path, but a different path that reflects a kind of desire for change and an urgency for change. And we draw on some interesting design ideas to suggest how change might happen. And we propose some probably unexpected ways of being, I guess, not the usual suspects in administrative justice. So Nick, do you want to say a bit more about those ways of being?
Yeah, well, so here we draw really on our shared experience of the Ombud institution and put the Ombud center stage. I think it's fair to say our sense of frustration is especially acute in respect of the Ombud. There's so much potential there, but probably much of it still unfulfilled. So as a result, we devote quite a bit of the book to explaining how the Ombud exemplifies some of the pathologies that we've identified, but also how it contains some of the remedies. To make our vision of the Ombud as vivid as we can, we deliberately get a bit playful, I think it's fair to say, in the book, and talk about the Ombud variously as a potential flaneur or flaneuse, storyteller, a bricoleur or bricoleurs, and a bridge builder. And of course, we don't for a minute think that Ombuds currently conceive of themselves in this way or sit around at conferences over a drink asking each other how their efforts in flaneury have been going on lately. But beneath the playfulness, there is a serious point about the importance of Ombuds not getting drawn into too legalistic or formal a way of conceiving their role. So we want these designations to help us escape from what we see as the cages really of user, system and closure, of individualism, over hygienic boundary observation and business as usual by way of resolution.
I think at some points we were worried that those who work as ombuds would find it all sort of an amusing folly, bringing out these concepts. But as you say, there's a serious point here and an opportunity for ombuds and others who operate in administrative justice, including ourselves, to be more relevant and less remote and more meaningful And in the book, we talk about design being about solving problems, but also about making sense and making meaning for individuals, but also, and more importantly, in a shared and collective way. So for instance, tribunals could do that, not through overturning of individual first instance decisions, but through capturing the patterns of the failings they see in those frontline decision making and turning that into learning, which amazingly still does not happen, as far as I know. And ombuds could do that, not necessarily through having increased powers or remits, but through engaging with networks, including civil society and others often considered to be outside the system of administrative justice, and through engaging with emerging practices in identifying the social rights implications of everyday decisions. For example, activists working with communities on rights to housing. This remoteness of administrative justice and human rights to everyday lives is perfectly illustrated by the Windrush Scandal here in the UK. For those of you who don't know about it, that scandal involved, and is still going on, but essentially involved citizens being deprived of their rights to work and to healthcare and housing because they'd arrived in Britain from the Commonwealth and Commonwealth countries as children. And in light of changed immigration laws and a policy that was literally named hostile environment, they found themselves being forced to document their status, which many were unable to do because they didn't have passports. They'd never needed to have passports. So many lost their homes, their jobs, and some were even wrongly deported to countries they hadn't been in for 60 years. What was happening should have been on the radar of the parliamentary ombudsman here years ago, but he says he didn't receive any complaints. And as a result, he felt unable to act without having what's called own initiative powers, or powers to initiate an investigation without having received a complaint. So unfortunately, the parliamentary ombudsman is now relegated to the fourth tier of the remote fourth tier of a complaints process for providing compensation to those affected by the scandal. And he is very much in post-production mode. But had he engaged with the journalists, including this own Amelia Gentleman, who wrote this book, The Windrush Betrayal, and was exposing what was happening a few years ago, and had he engaged with the journalists uncovering the story and with the advice centres that were working with individual cases, and also MPs and MP caseworkers who were receiving letters from constituents, and had all of those known about the Ombud, which they didn't appear to know, then the parliamentary ombudsman would have felt the tremors as those tragedies were unfolding and before so many victims had died. And that sounds really dramatic, but actually Windrush is a perfect case study for this siloed and rigid system we describe. It's a human rights and administrative justice tragedy. And it has roots in policy based on institutional racism, but also the lack of discretion given to Home Office decision makers and failures in processes of administrative review, which is a form of internal review that is used quite a lot for government decisions here, both of initial decisions on immigration status and later decisions made on compensation for victims. And it represents one of the biggest failings in the administrative justice system, basically the failure to look and to listen. And this is a quote from someone whose name is not really Martin. He was given a pseudonym in Amelia Gentleman's book, but she interviewed him because he was involved in the dealing with some of the cases coming in, and he was very angry about the way it was being handled, and he actually became a whistleblower exposing what had happened to some key documents that the Home Office held. And he says proof is something you do in a scientific experiment, probability is something you do with human beings. So for him, the initial decision making, they'd gotten it all wrong in the way that they were told to deal with these. So I guess, Nick, you and I are suggesting, you talked about being a flaneur, flaneuse. You and I suggest that an ombud who is flaneusing around the territory would be sort of sensing those tremors as they were happening and observing with a curious eye and a critical ear, and using those sort of skills as a storyteller to draw out the impact on individuals, and skills as a bricoleur to kind of piece together the emerging but disparate testimonies and evidence, and then skills as a bridge builder to facilitate the necessary conversations between state bureaucracy and its individuals at the front line, and civil society and the advice sector, and individuals affected by those decisions.
Yeah, and that's right. But I think we also wanted to show that this sort of language shouldn't seem entirely exotic, because actually the styles and practices that we see underpinning some of these designations have in fact already been represented in existing motifs within the administrative justice fabric. So, for example, we cite the public interest litigation in India in respect of social rights and the sorts of innovations to conventional practice and adjudication that have occurred there to make the courts more democratic and credible. We also talk about the deployment of the Ombud in Latin America, for example, and in particular in Argentina, where it's been described as a horizontal accountability mechanism and has a coordinating and networked function in tackling some of the highest profile social and environmental issues at both national and local level there. We talk about the work of the Ombud in Greece, particularly before 2008, in transcending formal administrative justice boundaries to promote equality for disadvantaged groups, and particularly for Roma communities in that period. And then closer to home in the UK, we talk about the joint initiatives taken by the Health Service Ombudsman and the local government and social care ombudsman together to derive real public benefit and structural change from patterns of individual grievance about health and social care. And the examples we cite in particular involve disabled people, as it happens. And admittedly, that might seem like a bit of an eclectic mix of examples, but I think we wanted to resist any tendency towards insularity and instead invite imaginative engagement with some very different, but also, in our view, some very instructive contexts.
And we also talk about other administrative justice institutions, including inquiries, and obviously tribunals and mediation, and what the culture of design can offer in reimagining these. And as you say, some of these are already in evidence. So one of the things we talk briefly in the book about is the design of the inquiry into the Grenfell Tower fire in 2017, in which 72 people died after a fire spread through their high-rise tower block. The inquiry, which is going on as we speak, reflects lessons learned from previous inquiries, and in a way it's an example of demos prudential design and design for social innovation. And I think it aims to recognize that Grenfell Tower was both a community and a collection of individuals and families with rich lives and stories to tell. For all the criticism of the inquiry, and there certainly has been plenty, it's placed those who died in the fire at the forefront, literally, in the sense that it opened with 2 weeks of commemoration hearings, focusing on pen portraits of the victims. And also the inquiry recognizes hundreds of what are called core participants, who are both individuals and organizations, who have recognized status within the inquiry, and whose testimony and questioning of the evidence will help shape what's learned from the inquiry. And we also note that one of the developments in tribunals, which happened before we all got, before COVID zapped us into the Zoomosphere with no notice, but some of the things going on with online hearings. One of the things that we quite liked was the online continuous hearing, which was an attempt to redefine the hearing as an ongoing dialogue rather than a one-off event. So hearings could take place over time and in a number of stages at a pace set by the parties, and with ongoing engagement between the judge and the participants, in a way that really allows for that promise of an iterative and inquisitorial approach to become real. And it's also a process that recognizes that the user is in fact many users, and they're aided, not controlled, by the technology they use. And also with mediation, which is the area in which I work, we showed how mediation practices are actually themselves design features that can help shape or reshape these other administrative justice institutions. So we do mention the work of Kerry Minkle-Meadow, who's a well-known mediator and law scholar who writes of the sensibility of mediation and the way it needs to adopt a feminist sort of emphasis on needs. And if we think of the aim of mediation as being not resolution, but recognition and reciprocity, which is what Minkle-Meadow suggests, then its techniques of listening and of enabling many voices should and do have a place within the work of others in administrative justice, including tribunal judges and ombuds, as we imagined.
Yeah, so when we seek to extrapolate from ombud practice to considerations relevant to the administrative justice fabric as a whole, we do have a special place for mediation. That's mediation really as an overarching set of practices, which if deployed imaginatively can be a vehicle for the expression of compassion on the one hand, in the basic sense of entering into and sharing bad experience, and also an ethic of care as a means of escaping together from that bad experience. And we're also conscious that the case for humane interconnectivity is more important than ever in the face of digitalization and no doubt after COVID too. So when we talk about tribunals and public inquiries, for example, we have at the back of our minds the way in which the ombud, shaped by humane practices of mediation in that broad sense like this, can fan out its influence to inform practice in those forums also. So it's not that we're suggesting that the ombud should make a takeover bid for the whole of the administrative justice scene, or that ombuds are always living up to their potential now, but we do want to ask whether the ombud as ideal type, if you like, might be a better starting point for a reimagined administrative justice fabric than the courts, with the adversarial trial as the universal template, the sort of hidden ideal. The idea that administrative justice is primarily a cognitive exercise in court-like adjudication, dispute resolution, and hygienic process simply sells it short, we suggest.
Yeah, I'm going to stop the screen share now, because that's it for our images, Nick. Just to say that in our final chapter in the book is on the politics of administrative justice. And I've long had the sense that ombuds are wary of straying into what they see as the forbidden zone of politics, at least in this country. And mediators too, I think, often interpret their responsibility to be impartial as one of being apolitical. But this is problematic because it's difficult to separate administrative justice and human rights from the political, especially when we're describing the way the state is perceived and the way it behaves and its potential to foster equality and positive notions of citizenship. What do you think about that on politics?
Well, I think it's certainly true that we think that what we say, it does entail a particular sort of politics in the broader sense of being about relationships between citizens and indeed non-citizens and the state. But administrative justice and human rights are, in our view, really, I think, unavoidably implicated in such issues and really lose all traction without that political context. So that's why we devote the final chapter to the political implications of the book. And here we draw on a cluster of interrelated sources to make our case. The American theorist and lawyer Danielle Allen for the rejuvenation of an Aristotelian notion, really, of political friendship, and for the ideal of the connected society, as she calls it, and for bridging institutions as ways of making those connections that are based on something other than the personal bonds of affection in private life. We draw on Martha Nussbaum for finding in human rights a necessary link with ideas of human development and capability. You've already mentioned Ezio Mancini, who has practical exercises in social innovation and in his work. And looking back a bit further, we have resort to the British social scientist and political theorist T.H. Marshall for that basic ideal of social citizenship. And I think implicitly as well to Raymond Williams, the cultural theorist and literary critic who was so prominent in promoting the idea of a common culture in the 1950s and onwards. So I think underlying that final chapter, and indeed the entire book, is an implicit recognition that law and politics are inseparable, and that any attempt to set up the rule of law as autonomous from and superior to politics is certainly misplaced.
Yeah. So we finished the book, we completed it a couple of years ago, Nick, and obviously a lot's happened since then. Understatement of the year. Lots happened. But for me, that raises two questions. So, and I don't know whether others might have these questions for us. Is what we say still relevant, both in terms of the loss, possibly permanent, of face-to-face interaction, and also in terms of the economic ramifications of COVID? And I suppose I would say yes, and even more so. If we move forever to online hearings and mediations as the default, which I know some people are speaking of, we'll have lost that physical proximity that's so important to trust and relationships. But we'll have gained the possibility of including many more voices in deliberative discussion than we could do before COVID. But I think we need to consider what we want to, in essence, what we want to save from the COVID fire and what we can lose to it. And also in terms of cost, what we propose is really about sustainability. And it's about what do we need for administrative justice to be like, so that it not only reshapes this crucial relationship, but it also puts an end to the resource-intensive assembly line that we referred to earlier. So that was my first question. My second question is, given what's happened since, what would you like to expand on in the second edition?
Well, it's certainly true. A lot's happened, of course, but I think the book still seems to me to be timely and maybe even a little bit prescient. There are quite a lot of issues that do invite further reflection. At one level, there's a lot more to be said, I think, about the intellectual framework within which the argument is situated. We didn't want to clutter the book with lots of footnotes or analytical discussion, but the argument does entail and derive from a serious position on the respective merits of politics and a certain sort of legal constitutionalism. And I think there's more to be made explicit about that, not least about how what we propose in some ways tries to harmonize the stars of legal theory that are sometimes called liberal normativism on the one hand and functionalism.
I was thinking in terms of what I would like to expand on also would be more about design culture, but not least in the face of this digitalization and artificial intelligence and automation. And in this series that Paul's been hosting, several speakers have touched on how automated decision-making is likely to affect frontline workers, frontline decision makers, and their relationships with citizens. And it seems to be physical proximity seems like a design ideal that we need to hold on to in state agencies as well as in public spaces. And it's essential for that connected society that you mentioned and for meaningful accountability. And I suppose just on a more personal level, I'd like to explore further how the practice of mediation has wider significance for these principles that we set out of community, network, and openness. So for example, in special educational needs and disabilities in particular, which is an area regularly described as being in crisis, there's great scope for making these connections between social rights, collective interests, and initial decision-making that would foster much needed trust and reciprocity.
Yeah, and I think perhaps above all, the implications for meaningful intervention by administrative justice institutions in the regulation of street-level bureaucracy do need to be more explicitly aligned with the tremendously rich empirical research that we've heard about in this series of seminars. I think all the previous speakers have in different ways emphasized how the relationships between citizen and state are played out daily in those frontline encounters, and how the place of law and rules in those encounters is always subtle and complex. We believe that the picture we've painted of administrative justice and human rights is consistent with our perspective and actually doggedly realistic, in that it acknowledges the complexity of those relationships and certainly refuses their easy reduction to a cartoon version of individual rights on the one hand, pitted against state intrusion, with state intrusion in turn personified by overzealous bureaucrats and their rule books. But it's a picture that we'd like to paint again, I think, in still more vivid colours, and maybe even in more than 2 dimensions. So if anybody out there wants the film rights, just give us a shout.
How about sculpture?
The sculpture, yeah.
Oh, thank you both very much for that fascinating discussion. I promised to put the link to Margaret's project in the chat, so there it goes. Have a look at that and the fascinating work Margaret is doing. And if you have questions for Margaret and Nick, post them in the Q&A, and we will get to them. One question I did have, and you know, we perhaps this is because I, like many others, have the cartoon version of things in my head. But the state and government in a reimagined world of administrative justice is still unavoidable. What do you do in a situation? What does an ombuds do in a situation where the government is recalcitrant, where the government is refusing to budge or refusing to engage? For whatever reason, it might have political reasons, it might have a particular view of what the law requires. What does the ombuds do when confronted with a brick wall of refusal on the part of a government entity?
Well, shall I have a go at that one, Margaret?
Yeah,
Yeah.
sure.
I mean, I think in some ways that goes to the very heart, Paul, of the sort of different visions of administrative justice that we're putting forward. I mean, I suppose if it gets to that stage, it rather suggests that there's been a breakdown in the sort of vision we're trying to promote, because the ombud is almost by definition anyway, has a mandate of influence rather than sanction, and it's quite striking in some contexts that when people want to criticize the ombud, they want to give the ombud more legal powers and in some cases give enforcement powers. But that seems to be the admission of failure, I think, according to the version we're trying to promote. So the idea of the state and government as the implacable foe, I suppose, is one that we would see as being sidestepped at the very beginning by the creation of relationships between an ombud and the institutions that it engages with. That can very often be more easily done on a local level, and I think you probably do see that more obviously in small states and small jurisdictional contexts. So admittedly, it's more difficult in a bigger setting. But I think that although in the UK, for example, have been celebrated examples of public dispute between ombuds and government departments, they've rarely ended very happily or very quickly for very many people, and indeed have often become a distraction. So I mean, I think it is a key issue, and in a sense, the answer to the question probably does involve that change of mentality that needs to be at the beginning rather than the end. But I don't know whether, Margaret, you feel that's a fair answer.
Yeah, I mean, I suppose one of the things I would also think is that you know, the importance of the network, the sort of horizontal accountability network in making sure that what comes out from the ombud in terms of recommendations is known. People are aware of it. People put pressure where pressure can be put, and whether that's through putting pressure on MPs or in other ways. But actually, probably the bigger problem, certainly here, would be not a government department or local authority refusing to implement a recommendation, but just doing it badly or doing it too slowly or just not really doing it right. And I think that's probably what more people experience following recommendations that come out of an Ombud investigation? Is that kind of just hobbling along, just not doing a good job of putting things right and improving things?
Just as a sort of a follow-up to that, and I see some questions coming in, so I'll get to those in a moment. What's how important is trust in this sort of scenario? I mean, how important in reimagining administrative justice is it that ordinary people trust in the ombuds and the other institutions of state to have their best interests at heart? And sometimes, perhaps we're back to the cartoon version again, but there's perhaps a gravitation towards legally enforceable rights and rules because there's a lack of trust in government officials to do things the right way. Is there anything to that, and how do you go about building trust if trust is necessary to the sorts of relationships that you're talking about?
Well, I mean, in special educational needs and disabilities, it is a real problem, Paul. I mean, that is probably the reason most parents and young people give for wanting their day in court, wanting to go to tribunal, and they do trust that their interests will be protected in a tribunal context, less so if they're going to the ombud, for instance. But the trust is lost so early in that relationship that you really have to go back to the initial sort of contacts that people have within, say, the local authority education team making the decisions. So I think one of the things that I think fits in well with what we say in the book is that what Nick and I both see in tribunals and mediation respectively is a failure that happens early on in that original decision made normally by a panel, which is a closed process, and there's no involvement of the individual in that. There's very little explanation given of the reasons for the decision. So there's something going wrong much earlier, I think, and it's difficult to repair that. But there is also trust, you're right, with the institutions of administrative, lack of trust with the institutions of administrative justice, and there's certainly some very vocal critics of the public sector ombuds here who feel they've been captured basically by the departments that they investigate. Maybe Nick, you have a solution to that, do you? I don't have a solution.
No, I don't think so. But I think it's worth bearing in mind Bernardo Zacca's work actually here, and the sort of picture he presents of the democratic state on the front line, and the importance of that democratic front line, that bureaucratic front line, representing the diversity of the community it serves, for example, and being attuned to the diversity, the pluralism of views and values that the community serves. And clearly that's a task that not all government departments have succeeded in turning around. And so that, again, that creation of trust, I suppose, goes to the very heart of the sorts of relationships in administrative justice between citizens collectively and the state, and then citizens individually in the state need to address. And that's a very subtle, I think, as Bernardo Zacca demonstrates, a very subtle interplay of lots of different factors. And I suppose it's recognition of that complexity and a better understanding and education of that complexity, which perhaps gives hope for making at least some progress in the right direction.
And in all events, it's not as simple as passing the Trust Act 2021 and requiring requiring people to trust each other. From Gary Yee. Hello, Gary. Gary is a very experienced tribunal adjudicator in Ontario, many years of experience, and leading figure in Canadian administrative justice. He asks, he following up on the trust issue, that's why I'm coming to this question now. He says he likes how your fascinating ideas get us closer to equity and social justice, but he asks, what is the risk that moving away from traditional rule of law and an adversarial system may lead to tribunals with too much power and discretion? Maybe this only works well if we can trust the humanity and empathy of the tribunal members. I think the model there is probably an adjudicative tribunal, which is deciding on rights and obligations. Where does that fit into your reimagination project?
Nick, you want to have a go at that one?
Yes. Well, I think discretion probably is the key word here, and I don't think we're talking about absolute discretion. Perhaps we're talking about the way in which principles rather than rules can provide the framework within which decision making is conducted, so that it's not that the alternative to a rigidly defined rule of law, or if you like, the sculpture we showed at the beginning, it's not as though the alternative to that is complete anarchy. But that there is more discretion and the recognition that, particularly if administrative justice is about relationships, that sort of discretion is exactly what's needed to get the right answer. And I think, I mean, speaking as somebody who's also sat in tribunal settings myself, the way in which, for example, sort of rules of evidence, standards of proof, and so on, and indeed the process that is expected in an adversarial context, can very often just seem totally inappropriate in what, after all, certainly in the UK in the tribunal context, is a more inquisitorial mandate. And yet we seem quite reluctant to let those things go. And I've been struck on some sessions I've sat in on, training sessions for tribunal judges during COVID, how there's been quite a lot of talk about the loss of formality and control in remote hearings. And I've even heard it suggested that it would be a good idea to develop some software so that instead of people appearing randomly on the screen, as I think we're doing now, that there should be some hierarchical structure, so that the members of the tribunal panel appear along the top, and then everybody else below, as it might be in a court setting. This would be a way of imposing some discipline. I just sense that there's a whole culture there, an ethos that probably is constraining rather than liberating. But again, the alternative is not anarchy, but perhaps a principled context rather than a rule-bound context would help get the balance better.
Yeah.
My colleague Elizabeth Sanderson asks whether you have considered in your work the resolution approaches of Indigenous societies. This is a significant topic in Canada. Elizabeth mentions Professor John Borrow's work. I don't want to say that any of Professor Borrow's works are his most notable, but certainly his book on the Indigenous Constitution from 2010, I think, is a significant piece of work. Elizabeth also notes that Professor Sanderson notes that Canada has tried alternative approaches to residential schools claims. So these were schools to which Indigenous children were sent. They were taken away from their communities and sent to these schools in order to Canadianize them. And there have been mass torts arising out of these. We've had a Truth and Reconciliation Commission. We had 25 years ago now, a Royal Commission. There's also something called the Independent Assessment Process, which is a deformalized claims mechanism for residential school survivors to bring claims. So a web of different mechanisms of redress, but underpinned by an appreciation that in Indigenous societies, the resolution approaches are very different and might in some ways approach reimagination that you envisage.
Yeah, I mean, I don't know enough about those, Paul, but you know, from what I do know and what you've said, it does sound like it fits in very, very well, because I assume one of the things that's really key in that, in terms of one of the key principles, is about the meaningful and affected by that in designing the mechanisms or the forms of redress, or the sort of paths to reconciliation, which of course is not really true of administrative justice in the way that we're talking about as a system that's been very much imposed kind of from the top down. So I think it would be interesting to know a bit more about that, and I'm sure there's a lot of I'm sure there's a sort of rich seam of things that we could explore in that really ties in well with what we've said.
I suppose just to add to that, I think probably some of the things we've touched on bring us close to considerations of legal pluralism, really. And I'm mindful of the fact that certainly the UK parliamentary ombud some years ago used to talk quite a bit about the ombud system. I mean, what was the word system that was used, but the ombud system being an alternative system of justice, in a sense, to the main civil courts. And I suppose when you go back to the very origins of administrative justice, Dicey and so on, it was the terror of that alternative system, in a sense, which would set the whole rule of law debates going. So I think it's controversial territory, but I can see very much the resonance of those indigenous approaches to the sorts of things we've been talking about. Yeah.
Susan Oppler, the City of Toronto Ombudsman, says she's excited and inspired by your ideas for the future, and thanks you. And certainly there's such a rich book with many themes and possibilities to explore. The alternative view, though, as expressed in the chat by another commenter, is that the ombuds, in a sense, is helpless, and I think this goes again to the legal pluralism point, and different ways of thinking about what law is. And you touched on it earlier as well in your responses to one of my questions. The idea that because the ombuds can't formally order a sanction or formally issue a sanction, it only has a power of recommendation. Is this something which holds the ombuds back? But I suppose you'd say that represents a traditionalist vision of what law and rights are, which is the sort of vision you're pushing back against.
Yeah, well, I think so, certainly. But I'm also mindful of again, one of the other speakers in this series, Mark Hertoghe, who did some very powerful work some years ago on the effectiveness of the ombud in the Netherlands compared to judicial review in bringing about changes of perception within government departments. And I suppose that there is more work to be done there, empirical work, no doubt, on impact, difficult though it can be to measure. But I suppose if we take seriously everything we've read over the years about reflective regulation and the drawbacks of the alternative command and control approaches, then we do need to take seriously the possibility that actually these so-called soft interventions can be more durable and sustainable. Certainly in the UK, the conformity rate of public bodies to ombudsman recommendations is very high, and I suppose that does go again to the question of trust and credibility of the institution, which can take a long time to establish and very quickly be lost. So I mean, I think invariably that does become one of the critical questions, and the idea of the toothless ombud has been around for a long time. Articles written in the early 70s about the UK ombud, describing it, ombud mouse or ombudsman. It used to be the tag, I think.
Well, the same criticism, of course, has been thrown at mediation for being toothless and sort of not being robust enough in facilitating people to to enforce their rights. And you know, it is a problem. It's the lens through which you look at it, and in terms of the expectations. And as with the compliance with Ombuds recommendations, compliance with mediation agreements reached in mediation is very high. But I think then the question comes about the perception of compliance, and also what we don't have a lot of empirical evidence on, as you say, Nick, on the sort of effectiveness of Ombud recommendations, nor do we have it on what happens after mediation, after these things have been implemented. So I think we do have a bit of a gap in our knowledge. I think those of us who practice in this, we spout these things. I mean, I'm being self-critical here about these alternative so-called softer approaches and how effective they are, but actually we do need to know more about them.
Switching gears a little bit, Aisling Ryan says that she was really taken by your book and has been wondering about your views on translating administrative justice reimagined into first instance decision making. And she's wondering in particular if through bridge building and open-ended approaches, we will swell the size and increase the bureaucratic layers of the state. And considering public administrators and bodies that have long established functions, cultures, and methods, is it a matter of undoing a few stitches before knitting the fabric back together again?
Lovely image. Thank you for your review as well, Aisling, and your comments. I don't know, I need to think about that a little bit. Nick, have you got a response to hand?
I'm thinking actually saying them really that, yeah, so we're in danger of creating a bloated bureaucracy because we're giving them more to do, and we're substituting what might be fairly quick off the cuff decisions almost with a more deliberative and iterative approach that could go on forever. I mean, I suppose the first thing to say is that our perception is that it's so much the other way that it's worth making the counter argument and hoping that you get to a reasonable balance in the middle somehow. And I think, I suppose, horses for courses and proportionate dispute resolution, I think in our view, has a slightly bad name because proportionality has so often been judged by questions of value for money, so-called. But I don't think that's to detract from the fact that clearly horses for courses is a desirable outcome in the sense of there being different techniques and different approaches for different types of problems. But I suppose the reimagining is partly that the reimagining the problem, reimagining the solution, and reimagining the processes that fit those different solutions. So it's not that it would be all in one direction by any means, and it could well be. And I've sat in ombuds offices myself, and you know, seen investigations that probably attracted disproportionate resource because the discretion didn't work the other way. It needs to go both ways, and I've certainly seen that in tribunals where you wonder whether you're not using a legal sledgehammer to crack a very small relational nut. So I'd like to think that with a bit of skillful footwork that outcome could be avoided.
And I think, yeah, I think the reknitting is also a little bit about investing where you invest the time and the effort. So a lot of the things that become problems later on are about a very simple sort of failure to literally failure to look and to pay attention and to notice things and all of that, which presumably takes a bit more time. But I was thinking about the Windrush scandal, and one of the things that came out in the review of that and in Amelia Gentleman's book was that the Home Office had replaced the frontline decision makers with very junior staff as a way to save money, and they had very little discretion, but also they had very little knowledge and understanding and experience, and they didn't understand the legacy of empire and what that meant in terms of the people who had been living here for 50 or 60 years. They just didn't know any of that. So one of the recommendations coming out of that is to train people and to really invest in your resources. So in a way, it's almost like, well, don't we need to just make that investment earlier on in terms of those processes and how they work, because they get bloated later on when it's really too late and it's after the fact.
I can permit myself one last question. What I really enjoyed about, well, you know what? I was about to take Professor Michael Adler's name in vain, but Professor Adler has himself posed a question, so I'll let him do that. So Professor Adler says that one of his main criticisms of administrative justice is that it has placed too much emphasis on redress, on appeals to tribunals and courts and complaints to ombudsmen, and not enough on first instance decision making. Some years ago, the Administrative Justice and Tribunals Council of the UK published a very important report, Getting It Right First Time. In talking about Windrush, Margaret referred to the fact that the parliamentary ombudsman had never received any complaints about Home Office decision-making. Professor Adler's view is that what is needed, more than anything else, are serious attempts to improve the justice of first instance decision-making, which would involve identifying the relevant principles, trust, dignity, and accuracy, and setting up independent procedures for assessing the justice of first instance decision-making without the individual needing to appeal or complain. And he's interested to hear your take on that.
Well, hi, Mike. I mean, I think Nick and I are both nodding because we probably agree completely with that and the importance of getting the first instance decision making right. I'm not sure about the administrative review. I mean, I think the principle of that was a good one. Obviously, you want things to be sorted out as early as possible, and the idea was a second decision maker could review the decision made if it was challenged. But I'm not sure that that's worked the way it was intended to work. So what's happened is, you just get the many stages that you have to go through, and the many hurdles. And there's a lot of attrition on the way, and very few complaints actually get to the parliamentary ombudsman. But I mean, I completely agree that it's about getting that first instance decision making right, and that's why I think looking at the application of principles as opposed to rules, and the appropriate use of discretion, and the diversity that, as Nick reminded us, that Bernardo Zacca was talking about, are really essential. But that hasn't been what's been prioritized.
No.
Nick, do you want to add to that?
Yeah, I think so. And I think I'd come back to the prominence we give to the Ombud. I mean, it's certainly true. If the Ombud is seen simply as what it was called, I think, again in the 50s and 60s, as a sort of grievance man, and the man was used very explicitly and deliberately, I expect, then the Ombud seems to be a pretty limited resource. But I suppose the sort of vision for the Ombud that we're trying to promote is one where prevention, as much as cure, is part of the mandate. And indeed, one of the very live debates in the UK in recent years has been whether or not the Ombud should acquire so-called own initiative powers, and Margaret touched on this. And the whole point of that, I suppose, is partly to be engaged in prevention improvement rather than retrospective remedy, and indeed to have an active relationship through networks of regulatory agency with public bodies, so that there can be input. And we've seen in the UK and elsewhere, it's even more developed, the role of the Ombud as an educator, cascading lessons from the empirical experience of handling complaints to try and improve first instance decision. And I mean, I think it's very clear, just in terms of volumes and the weight of cases that potentially can be generated as ombuds get higher profile, and indeed as the system as a whole gets higher profile. It's impossible to conceive of a system that can, or a fabric that can respond to those individual grievances effectively, when potentially there are so many. So that longer term, the only solution can be getting it right first time. I suppose the question is what structures, what infrastructures, and what institutional interventions can most effectively do that. And I think one of the things we're saying is that we're just skeptical about the ability of tribunals and courts to cascade those lessons down, and that if they're going to play any part, it needs to be a more imaginative one with a greater range of techniques.
To wit, Brian Thompson, afternoon, Brian. I'm sure you know Brian from the University of Liverpool. Asks, is it more likely that the reimagining you envisage might happen more easily using a strategic approach, deploying the own initiative method, and hope that political pressure brings about systemic change?
Well, yes.
Well,
I mean, yeah. Sorry, Margaret, go on. Yeah.
No, I was just going to say, I mean, I think everybody sort of concluded that change isn't likely to happen anyway. So regardless of whether we think own initiative is going to bring about some major change, I also don't think it's necessary because, you know, as Mick King, who's the local government and social care ombudsman, has said quite a bit. I mean, you know, they're already doing that within the powers that they have, and there are, I think, we suggest some ways by working within a network and taking on some of these behaviors, you actually don't need that change in the legislation in order to take on that more proactive role. Sorry, Nick, I interrupted you. What did you want to say?
No, well, I think that's absolutely right. I mean, I think it's debatable whether the own initiative power per se is entirely necessary. It's probably emblematic, though, of a different approach. I mean, it's very striking that in Europe, I think there are only 7 countries where the national ombud doesn't have that power. The UK is one of them. Most of the others are quite small, including Liechtenstein and 1 or 2 other smaller jurisdictions. So I think the own initiative has maybe become an emblematic issue, and I think the danger possibly is a drift towards trying to make the ombud a regulator, which possibly would be to go to the other extreme. The peculiar hinterland the ombud operates in is I suppose is that landmark between the empirical experience of handling complaints and the bigger structural strategic intervention, but having the ability to mesh the two. And perhaps what's needed is a greater element of selectivity in terms of the complaints that are then used to develop bigger lessons, because it's very random and there's no guarantee at all at the moment that the complaints that get through to an ombud, very often at the end of quite a convoluted process, are going to be representative of anything. So an element of strategic direction would seem to be a better use of resources and something that was more purposeful, I would have thought. But there are, as Margaret says, within the existing powers, opportunities to do something that almost gets that far. And certainly the educational role is very often implicit, but perhaps not prioritized enough.
We also propose in the book the idea of a super complaint, which of course came about in terms of consumer protection and the Enterprise Act, but has now been rolled out to financial services and now more relevant to us, to the police. And of course, very relevant right now in terms of what's going on in this country and the police. But that's something that I think is relatively new. But I mean, the idea is that say with Windrush, a super complaint could have been taken to the Ombud to allow for an investigation in a kind of own initiative sort of way. So that was just another idea that we include in the book as something to consider.
All right, one last question for you, and it's one of the things that struck me reading the book was the massive social and cultural changes which underpinned, you say, different understandings of administrative justice. So after World War II, you have the rise of the UN Declaration and all the rest of it. Then you have a displacement due to the rise of neoliberalism, as you describe it, and the new public management becoming the the zeitgeist of government. And Professor Adler has written of how models of administrative justice had to change to take account of the new public management. So these, and this led to the user focus that you speak about in the book, and thinking of people as users rather than as citizens or as people. And it makes me wonder then, what is the next big social and cultural shift which will underpin a reimagined administrative justice which is more responsive and reflexive? Is there going to be, would it take a shift like that? Is there going to be one? What would it take, in your view?
Well, we may have a beverage for the 21st century. Who knows, after COVID? I don't know. I think that's a really interesting question, Paul. I'm not sure. Nick, have you got some ideas on that? I think it's really difficult because there's so much when you think about the impact of populism and populist politics. You think about COVID and the huge impact on everyone. We are sort of in that kind of, where we hope to be in a sort of post-war zone, don't we? When we need to recalibrate and reconsider. And there is a lot of talk of kindness. There is a lot of talk of how kindness has been nurtured under COVID, but also the huge inequalities that it's exposed. So I'm not sure how optimistic I am. What about you, Nick?
Well, I'm not sure about optimistic. Maybe hope is a different version, a different virtue than optimism, if optimism is a virtue. I mean, I suppose one would have to say, I mean, COVID in a way could well prove to be the catalyst for exactly that sort of generational change that you've mentioned, Paul. I mean, I feel as though it's become increasingly obvious that there's a sort of internal contradiction in the setup that we've gradually inherited since the 70s, where just at the time when regulatory operations have become more dependent upon individual enforcement and litigation, if you like. So at the same time that the retreat of the state has left many of the infrastructures for delivering that sort of system extremely bare. And that goes back to Mike Adler's point about therefore the absolute necessity of improving first instance decision, and also to Brian's point about possible advantages of a strategic approach. I don't know, Danielle Allen, I mean, having talked in her book, Talking to Strangers, a lot about the connected society and bridging institutions and so on, I noticed in her more recent collection, edited, called From Voice to Influence, she started talking about rooted cosmopolitanism as the way forward. So that balance of the local and the general and democracy being built from the ground up. And I could see that having repercussions in the administrative justice sense, and repercussions that perhaps would be consistent with what we've been talking about, which would be the establishment of those local networks and that local engagement with perhaps local regional ombuds, for example, and other tribunal forms perhaps, but with more inputs and local ownership. And I'm just thinking back to disability rights involvement days when I was involved with the disability rights world. The importance of engaging disabled people in follow-up was always regarded as absolutely essential. It's like nothing about us without us. And I know at the Disability Rights Commission, when we did formal investigations, it was always stressed that it was very important that disabled people themselves on the ground would be the people who would say whether or not those investigations had yielded fruit, and they would in a sense be engaged in the follow-up process and the scrutiny. And perhaps we now live in a world where that sort of scrutiny is feasible, and post-COVID may become indeed increasingly desirable.
Well, we will see. Gary Yee came back in the Q&A with a comment about how this is a fascinating conversation, and I think it is a you two have had a conversation. We've all had a conversation, and really what your book is designed to do is to start a conversation about new ways to think about administrative justice, not necessarily a one-size-fits-all solution, as Gary suggests, but one which might be adaptable to different circumstances. And certainly, I got a lot from reading the book. I know that many of the reviewers often did, and here's hoping indeed that it is the start of a conversation which will lead to meaningful change in how we perceive administrative justice and how we administer it. So it remains only for me to thank Margaret Doyle and Dr. Nick O'Brien for being with us today. The book again is Reimagining Administrative Justice, Human Rights in Small Places. A wonderful, thought-provoking book, and this was a wonderful, thought-provoking conversation. So thanks to you both, and good luck and stay safe.
Thank you very much, Paul.
Thank
Thank you to all of those who came.
Indeed. Thank you.